time.
I'm sorry, it was muted. It was muted.
All right.
Yeah.
All right, I'm calling 22178881. Looks like we were on mute. This is Auto Club Group versus Tarisha LaFleur. The matters before the court set on for a first hearing. It looks like after the filing of the responsive pleading in this matter. I know we got a late start. My apologies to all involved. Your appearance for Auto Club, please.
Good morning, Your Honor. Joshua Kosmeric, P80941 for the plaintiff.
All right, thank you, counsel. Good morning to you. For defendant, do I have Tarisha LaFleur on this Zoom or anyone representing?
Oh, you was in line. I'm sorry.
I'm sorry.
Yeah.
What's your name?
Yes, this is Tyresha LaFlora.
All right, thank you, Ms. LaFleur. Ms. LaFleur, I do have the answer that you filed in relationship to this matter. Counsel, did you receive the answer as well, sir?
Give me $921.
I did, Your Honor. I'm sorry. Someone's speaking in the back. I did receive Ms. LaFleur's answer in this matter.
All right, have the two of you spoken at all regarding whether or not there is a possible resolution short of discovery in this matter?
You got 11.
We have not, Your Honor. I believe that this is a matter that if we open discovery.
2 midday evening.
Ms. Hall, whoever is that on Ms. Hall, I muted you once. If you come off of mute again, I'm gonna discontinue the hearing because you're interfering with the hearing. All right, I'm sorry, counsel. All right. I know that the claim here is for some $18,000 or so. All right, so Ms. LaFleur, the case has been joined, and so now what's going to happen is that I'm going to allow a period for what's called discovery. That means that the plaintiff will be able to request information from you in the form of interrogatories, request to admit documents, and that process is generally referred to as discovery. You can also submit questions to them regarding this incident. If you believe that they have any documents in their possession that would be helpful to you in your defense, you can request such documents, and they will have to send them to you. So I'm going to set this up over on a 60-day discovery order. The next date that you will be required to be back in court, that date is going to be, I'm going to give it to you in just a moment. We're looking up a date that works.
November 21st.
All right, 11/21/22 is going to be the next action date. That's going to be at 9:45 a.m. Discovery will be open through that date. Also, both parties can file any motion that you wish to file in front of me and set it for hearing on that date of the 21st of November. If there is something that comes up that you wish the court to rule on or make a determination, you can file such motion and set it for hearing on the 21st of November. The only requirement is that the other party receive at least 10 days notice before the hearing. That information will be in my order under paragraph number 6. As long as you give 10 days notice of your desire to have that matter heard, the court will hear it on 11/21/22. This does not prevent a party from filing a motion for summary disposition in the future, but it allows the filing of such a motion and setting for hearing on that date if the parties wish to do so. I will set a schedule for motions at a later date, but if you see in the process of advancing this case that there is an issue dispositive or non-dispositive that you wish the court to resolve, you can set it for hearing and give 10 days notice to the other side, and I will look on that motion on 11/21/22. All right. So in the next 60 days or so, if you want anything from the other side, or if you receive any information from the other side, if you receive a set of questions, if you receive a request to admit, if there is a notice to take a deposition or anything along those lines, you are required to respond to the same by law. And so you have to do so within the time prescribed within any document that you receive. All right, so you receive an order from me in the next few days, the scheduling order, and that scheduling order will have the notice of hearing for the next day. All right, I wish you well, counsel. Good day to you, Ms. LaFleur. See you on the next date, 11/21/22. All right, good day to you.
Thank you.
All right, the court now calls case number 22-18-1636. This is One Detroit Credit Union versus, last name is Bailey. It looks like Shanticia Bailey. The matter is before the court for a status construct, for a initial conference, it appears, given that I have received the answer. The answer is dated in May of this year. All right, your appearance for One Detroit Credit Union, please.
Your Honor, Michael T. Mamet, PA 1102 on behalf of plaintiff.
All right, thank you, counsel, and good morning to you, sir. And again, my apologies for the delay in getting us started this morning. Thank you for being here. For defendant in this matter, or do I have Ms. Bailey or someone representing Ms. Bailey? Say something if you're here at this time.
Yes, I'm here.
All right, good morning to you, Ms. Bailey. I remember I had this case in front of me now, previously, counsel, and I think the two of you, you and Ms. Bailey talked, or am I mixing this up with something else? Talk to me, counsel, and update me.
Oh, no, you're right. I don't believe, I'm not sure if there was another appearance. I would not have been at the, I would not have been at the previous hearing. However,
Gotcha.
if I could get a quick breakout room with Miss Bailey to see if we could resolve it.
All right, let's do that. Ms. Bailey, I'm going to give you a notification to go and talk with the attorney on the other side. And so when you receive this notice, just go to this breakout room and you get a chance to talk about it, see if there are ways to work through this. There's a notification, and the attorney is going to meet you there in just a moment.
Okay.
There you go. The court now calls 22-18-1783. This is LBNB Funding LLC versus, looks like last name is Figueroa regarding the first hearing. It appears on this matter. I do have a responsive pleading and answer to the complaint filed in this matter. The complaint in this matter alleges damages of some $780.93. Your appearance for LBNB Funding, please.
Good morning, Your Honor. Brian McNulty, P number 42394, appearing on behalf of plaintiff. My appearance is limited for the purpose of today's hearing only.
All right, thank you, counsel. Your appearance is noted at this time, sir. Thank you. Do I have last name Figueroa on this Zoom, living on Copland Street? If you're on the Zoom, so say something. All right, the matter is set on for 9:45 a.m. It is now 10:48. Again, I'm looking for Figueroa is the last name, and also known as last name Rigor. The court has received the filing of an answer in this matter, and the court sent out a notice setting this matter on for today's date. That notice was sent out on June 24th, setting up today's date and time to the address provided on the answer. All right, and counsel, have you spoken with this defendant person today, or have they been in contact with you in any way, sir?
I have not spoken with her. To my knowledge, she has not appeared, Your Honor. I did call out during the waiting period a number of times for her, received no response. At this time, we would ask the court to enter a default judgment for damages of $780.93, plus our costs in this matter, including the filing fee and service fees.
The court will find, first of all, that the defendant is in default by the failure to appear in this matter, having received due notice to do so. The court will further find that the plaintiff is entitled to entry of judgment on the terms sprayed and complaint together with appropriate costs, and the court will sign the judgment upon its presentment. Now, that can be sent in or that can be emailed if you want to take the email address.
I will take the email address, Your Honor.
All right, that email address is Latifah, Latifah dot, last name is Hunter, Hunter. That's at 36districtcourt.org, 36th, 36districtcourt.org.
Thank you, Your Honor.
Thank
Yeah,
you, sir.
when your case comes up, yes.
I will
Another.
provide that information to, the attorney.
Seeing the woman?
Your Honor. Thank you.
Or you do have to keep your devices on mute because I am in the middle of hearing, so please keep your mute devices on mute until your case is called.
Have a good day, Your Honor.
Have a good day, sir. The court now calls case number 22-183381. This is LBNB funding versus Iola Hall. The matter is before the court, set on for a status conference. Record should reflect that this complaint alleges damages of $2,131.26. And the court has received an answer responsive pleading in this regard. Your appearance for the plaintiff in this regard.
Judge, may I please court? My name is Attorney Richard Rusin. I'm the attorney of record. My bar number is 35222, and I'm appearing on behalf of the plaintiff today in the status conference.
All right, thank you very much, counsel. Good morning to you. I'm looking now for Iola Hall, I-O-L-A. I'm not saying it right. Last name is Hall. Say something if you'd assume I see you there. Please unmute yourself and say something at this time. Last name Hall. You will need to hit *6 if you're unmuting your device. Hit *6. That'll get you off of mute.
She was
All right,
definitely
counsel.
having a hard time. She came down and then she went, they told her to go back outside. She wasn't able to work. the
So
phone
she was in
anymore.
person.
Yeah, and they told her to go back because she can't hold.
All right. She's the elderly lady.
Yeah.
All right, Mr. Rusin, I see that she's there. She's been having some problems with connections. I don't know why, but I noticed she came down to the court. I'm advised. And,
That's what I understand, Judge.
somebody sent her out and so on and so forth. So I'm trying to see if we can get her in. Have you had a chance to speak with her at all, or?
No, Judge, I would be delighted to speak to her if she can break in here. I know she's probably on there because she did check in with the clerk.
Yeah. All right, I do see her identifying marker there. But, Ms. Hall, if you're hearing me, if you hit *6, well, she just hung up. Maybe she's gonna call. Well, she didn't answer.
Maybe we could pass this for a few minutes, Judge. I have a lot of chamber work to do and it's okay.
Yeah, I'll come. I'll call you back before it's all over with, sir.
That'd be great. I'll go on mute again.
Thank you, sir. All right, this is case number 21-17-3498. This is Michael Eric versus. Yeah, Michael Elric, I should say, versus Jalen Brown, and looks like. I'm saying another name here, Tina Miller. Yeah, Tina Miles. All right, the matter is before the court, set on for a review hearing on today's date. For the plaintiff, your appearance at this time.
Good morning, Your Honor. Attorney Jessica Warfield, P85391. I am standing in place of Attorney of Record, Attorney Ryan Hill, on behalf of the plaintiffs.
All right, thank you. Good morning, Ms. Warfield. All right, I'm looking for Mr. Brown and/or Miss Miles.
Yes, Mr. Brown, I'm here.
All right, thank you, Mr. Brown. Good morning to you, sir.
Good morning.
All right, so it looks like you guys were in the breakout room. Can you update me, Madam Counsel?
Yes, Your Honor. So we were in the breakout room for a while. Your Honor, we have agreed to dismiss Ms. Tina Miles as a defendant in this matter, and Mr. Jalen Brown has agreed to consent judgments in this matter. Your Honor, there will be 2 consent judgments that he has agreed to. One for Mr. Michael L. Elric in the amount of $1,554.19. The other consent judgment, Your Honor, is for Auto Owners Insurance Company in the amount of $6,445.81, Your Honor. We have discussed monthly payments. We have authority from Mr. Elric for the $50 a month installments that Mr. Brown has indicated that he can make. Your Honor, however, we have not gotten authority from auto owners for that amount. And in all candor of the court, Your Honor, I'm not sure what you would like for us to do at this point, being that we have not gotten that confirmation from auto owners to allow that monthly installment. Are we able to enter the judgment for Mr. Elric? And I don't know.
Well, Mr. Alwick can certainly pursue payment remedies as it relates to the money that would be owed to auto owners. If he enters into the judgment, if they do not agree to an amount, then what Mr. Brown would have to do is file a petition for partial payments with the court. And when he files that, the court will make a decision based upon his ability to pay as to what the payment amount should be as it relates to the auto owners portion of this matter.
Do you understand that, Mr. Brown? I'm sorry, Your Honor.
Yes, I'm following.
So, once that judgment is entered, if they agree, I think counsel is trying to get a feeler out there to see if they're going to agree to a certain amount. But whether they agree or not, you can petition the court. It's a form called a petition for an installment payment. And you file that document and then it'll get in front of me. I'll review it and make decisions as to how much, you tell me how much you want to pay, and then I'll look at your resources and see what's a fair amount. If you don't have a lot of money, you don't have a lot of money. But I'll take a look at it and we'll figure it out. Okay?
Absolutely.
All right.
Your Honor, I would like to put on the record that a copy of these judgments have been sent to Mr. Brown. Can I get his permission in open court to sign on the one for Mr. M.L. Elric and auto owners? Do I have his permission to sign?
And what counsel is requesting, sir, is that he be allowed to go ahead and send those judgments to you to be with your signature or initial on it. And so the central question is, if it says what you've agreed to, that is $1,554 to Mr. Aldrich, and then another judgment of $64.45 to auto owners, the Eldrick judgment to be paid in monthly installments of $50 per month. Then the judgment regarding auto owners is an open-ended one that you're trying to work out something, that if you don't work out something, you petition the court and then I'll figure out what the number should be. That makes sense for her to sign off on those and send them to me.
Yes, sir.
All right, then, Madam Counsel, let me drill down on the start date for the $50 per month payment. So when is the first payment due so that we can establish it?
October 1st, Your Honor. And if it's convenient for Mr. Brown, he can send payments directly to our law office. The address is on all of the court documents that you have regarding this case, Mr. Brown.
Okay.
That date, that start date, October 1st, that works for you, sir?
So what I was actually gonna say was I actually get paid bi-weekly. So if it could start on the 14th, and then I guess every bi-weekly from then, well, not bi-weekly, but it'll be the 14th of October, the 11th of November, the 9th of December, and etc.
Excellent. That's why we work on these things right here. Okay, let's see if does that work out okay, Madam Counsel?
That works out perfectly fine, Your Honor. Just so you know, Mr. Brown, I'm going to amend the date from the judgments that I sent you. So it says October 14th, not October 1st, okay?
Okay, thank you.
Okay.
All right, very well. I will await the orders upon their submission to the court. I'll sign them, and then we will make sure that you get copies as well, Mr. Brown. And I wish you well, sir. All the best to you.
All right.
Thank you, Madam Counsel.
Thank you, Your Honor. Always a pleasure.
Always a pleasure. All right. We're back on the record regarding one Detroit versus Bailey.
All right. Good morning, Your Honor. Michael T. Mamet, PA 1102 on behalf of plaintiff.
All right, thank you, counsel. And I see that Ms. Bailey's back. I know that the two of you did go into a breakout room to discuss the broad parameters of this matter. Talk to me, sir, and update me regarding this matter.
Yes, Your Honor. And we were able to clear up the confusion between the last hearing and this hearing. Another attorney with our office appeared at the last hearing. So this is the first time that I've appeared on this particular case. And in the interim, though, the defendant believed that certain insurance payments would be made, or at least a claim filed to pay off, the remainder of the auto loan in this matter. And it sounds like that claim was just recently filed in the last 2 or 3 weeks, I believe. So instead of entering into any type of consent judgment or agreement now, I believe the defendant would defer to open discovery for the next 60 days if the court would allow, and see if in that 60 days those insurance payments come through. And I explained to her that if the insurance payment pays above and beyond what's currently due, we would refund her the balance of whatever's not owed. However, if it is lower than the amount that's currently owed, that difference would need to be made up by the defendant.
All right, Ms. Bailey, that's the nature of the discussion that you had in the breakout room, ma'am.
Yes. I finally got the paperwork from their credit union that I can file my information and give to the insurance company that they finally just sent to me maybe like 2 weeks ago, 3 weeks ago. And my doctor's office didn't give me the paperwork yet, so I'm not able to give it to them for the money to start coming through. So I would just need like a 30-day extension to get my paperwork.
All right. Well, yeah, it makes perfect sense then that the court will set this up as a case in discovery where the parties have the opportunity to exchange information. So I'm going to go ahead and set that over on a 60-day order. That'll get the time for any papers that have to be acquired, and also the submission of any applications for benefits. So that next date is going to be November
21st. Yes, November 21st.
November 21st is going to be the next date. That's 11/21/22, and you'll receive an order in the mail from me with that date on it at 10 o'clock a.m. 11/21/22. That order will allow for discovery, will allow for the exchange of information. It will also allow for the filing of any motion, whether dispositive or non-dispositive, that you may wish to file with the court. That is, if you're asking the court to do something or to order something, to file a written document and ask the court to do that. And all you need to do is make sure you give the other side at least 10 days notice of the issue that you're bringing before the court, and I will hear it on the 21st at 10 o'clock a.m. So I'm going to be issuing that order today. You'll receive something in the mail in the next few days. I do wish you well. Counsel, good day to you, Ms. Bailey.
Your Honor, real quick, if I may, in between the close of discovery and any possible submission of a dispositive motion, would we be able to have a final settlement conference possibly? Because if we do receive those insurance payments and there is any type of balance, I would, and I'm sure the defendant would appreciate one last opportunity to settle this without having to file any type of motion.
Right, and the motion filing part is not something that's required. And basically what the court will look to is setting a time to file motions at the next hearing date. So this is just something that if in the interim, the parties, something came up where you want to bring it to the court, I wouldn't want you to have to wait for a motion hearing date in the future to do that. If something comes up during discovery where you say, okay, I need to get this in front of the judge and get a hearing on it, that's what that date is about.
All right, perfect, Your Honor.
Yep. It doesn't
Thank you.
preclude, it doesn't preclude other motion filings, what have you, in the future. But if something comes up, this gives that way of resolving it. And indeed, if the parties have resolved it, that will be a date that we can drill down on the resolution and what happens next.
All right,
All right,
perfect.
Ms. Bailey.
Thank you, Your Honor. I appreciate it.
Thank you, sir.
Have a good day.
All right, thank you. Good day to you, Ms. Bennett. You'll get the order as well.
Thank you, you too.
All right, the court now calls case number 22-242346. This is Markeisha Wesley versus Detroit House of Pancakes. The matter is before the court on the filing of a motion to set aside a default judgment. The record should reflect in this matter that a judgment, a default was entered in this matter on the 15th of June of 2022. And that I received a motion, obviously subsequent to that time, asking that that default be set aside. Let me, do I have Markeisha Wesley on the phone, please?
Yes, I'm here, Your Honor.
All right, good morning to you.
Good
ma'am.
morning.
I'm looking for someone now from Detroit House of Pancakes. Detroit House of Pancakes, if you're on the Zoom, please say something at this time. All right, I did receive a letter from Detroit House of Pancakes. Just one moment, I'm reviewing that. It indicates that he received that the case be moved out of small claims. He never received a notice of removing the case, never received a hearing date. When the court received that, I did set this up for a hearing date, and I sent the notice of the hearing date to the address on Bagley Street, 400 Bagley, indicating that the party should appear on this date. I don't see anyone from Detroit House of Pancakes. The matter is set for 10 o'clock a.m. It's now 11:07, it looks like. The correct Zoom number and information is on the form, as well as the address that Mr. Higgins provided. Mr. Higgins says he's the owner of Detroit House of Pancakes, but he has not appeared today. All right, for that reason, the motion to set aside the default in this matter, that motion will be denied where a defendant has not appeared for the hearing. All right, so ma'am, I know that a default was entered against you, in your favor, and this was regarding a claim that you brought regarding $6,500. I think this had something to do with you having worked for that agency, and you said something about you didn't get paid. Tell me what happened, ma'am.
Correct. So when I was hired for the position, I was hired as assistant manager. They told me they would pay me at this certain rate. I don't remember if it was $12 or $14 an hour. That I would also receive tips with that rate. And once I received my check, it was like for $5 an hour, $4 or $5 an hour. I had been given away like tables. It was like, I was serving and doing like manager work. I was giving away tables because I was under the impression that I was being paid more in wages due to the fact that I was like the assistant manager. I was using my car to pick up items, during the time I was on the clock, and even times off the clock, I was helping with some administrative tasks, and basically just like, getting paid, I guess, basically $5 an hour for this managerial work I was doing. So after I received my first check, I just was like in awe and shock. And basically I had, brought it up to the manager, and he kept telling me that he would get back with accounting, and the manager was I'm losing his name right now.
Let me ask you this, Ms. Wesley. So you have one pay period where you saw this problem. Did you work for another pay period?
Well, like when I received the first pay period, it was like,
Let me stop you for a moment. That's a yes or no question. Did you work for a second pay period?
yes, it was like a week in the hole. So it's like I didn't really work. I it was like Martin Luther King Day, like January, but I didn't work after. Like I worked one day, and I was like, it was just like I was kind of like emotionally distraught, and like the morale was down, so I left that Monday. But I received that check on that Sunday, and then Monday I left, and then I still had a few days. So it was like I had a check pending still from those work days I had worked, but I didn't continue working after that Monday.
Okay. All right. So let me ask you, the first check that you received, was that for a 40-hour week or what was it for?
I
You know,
I
ma'am.
don't, I'm so sorry. I did lose my I did lose those checks. I did, and I don't know. I hadn't been reissued them, but I sent those to my I had someone consulting me on the matter. But if you just give me one moment, I'll.
Yeah. My question is a bit more, I think my question is a bit more intuitive. I'm trying to get it. How many hours did you work? You said
So I believe this second check was for 31 hours at $5 an hour. That one was dated for 1/28 of 2022. And then let me see if I can pull up the other one in my emails.
was that the first, the 128, was that the last check that you received?
I think that was the last one because the first one was like before Martin Luther King Day. The first one is January, March. This the first one was dated 1/14 of 22, and that one was for 44 .25 hours.
All right, so, and so if I calculate this properly, it looks like you got 75.25 hours when I combine the two of them together. That sound about right to you?
Yeah, that sounds correct.
All right, you said when you got the check, they paid you at a rate of $5 per hour?
Yeah, and then it was like the tips tax and that everything taken out. Yes, $5 an hour.
All right, so just one moment now. Just one moment. All right, so it looks like what your measure of damage would be here. You indicated that your expectation was that you're going to be paid $12 an hour. Is that correct?
Yeah, I believe so. I can't remember if it was 12 or 14. I wrote it in the notes back when I filed in
I do have
earlier this year.
Yeah, I do have the notes that you were going to be paid
Yeah.
$12 an hour.
Yeah, and I had yeah, I was under the impression that I was going to get paid more and it was going to be more lucrative working there. And I had other job offers, but I was just like under the impression that, it was better money, and I had positions that were offering me way more money, and I lost off on those wages in those positions because they became filled.
All right. Well, there's not a whole lot that you can collect in that regard. You took upon this opportunity anticipating that you would get paid $12 an hour, and you actually worked 75 hours, a little over 75 hours. So if I take 76 hours, at the difference between what they paid you and what they agreed to pay, they paid you $5 an hour. They agreed to pay you 12. The difference would be $7. They would owe you $7 for each hour that you work. So 76 hours times $7 an hour, that comes to $532 that they owe you. You indicated that there may have been an opportunity for additional tips that they may have earned if you had not given the tables to other people. So that might inure to an additional $200 or so.
You said additional what?
An additional $200. So my determination in this matter, based upon the information that you provided, based upon the law as it applies in these matters, I'll set damages at $832. You're entitled to your court costs in this matter, and I see that filed. You recall what your filing fees are, because they're not jumping right out at you. Recall?
I'm trying to remember exactly, but I know I had consulted a attorney in this matter, and they had wrote letters on my behalf. I don't think I had to pay because of my.
All right. So you got a favorite?
Yeah.
Okay. All right. Very well. All right. So you'll get the motion to set aside the default will be denied, and the default will remain in place, and the court will enter judgment on that default. That judgment on that default will be in the sum of $832. You'll get a copy of that in the mail from me in the next few days. You still at the address in Oak Park, is that correct?
Yes, and there's no damages awarded for emotional distress or any of the other things that arose in that case.
No, the law doesn't allow the award of damages for emotional distress under the situations that you described, and it doesn't allow for a measure of damages of lost opportunities under a situation where you were employed for such a brief period of time, and that's why I can't take those kinds of things into consideration. All right, ma'am. So we'll get that judgment right out to you.
Okay, and then also I had purchased some items like clothing that I don't wear, and like aprons I bought for the team. Can I get paid for those as well?
Just one moment.
I can submit receipts if you need them.
All right, the problem there is that you didn't allege that in your complaint. Let me ask you, how much did you spend on clothing for the job now?
Shoot, I bought maybe 3 pair of pants. They're about $30 each, and then I bought 2 white shirts, 2 or 3 white shirts. They're about $25 each, and then it was aprons I shared with the team. And I don't know, they were probably $8 a piece for maybe I think it was maybe 4 or 5 of us.
All right. All right, I'll grant you additional damages in regard to investment on the job opportunity at $150. That brings the judgment total to $982. And you're within judgment for that amount. Right. All right. Thank you, ma'am. Good day to you.
Good day. Thank you. I'm sorry. So that information just mailed over to me and the other party.
Yes, there will be a judgment form that has the amounts on it, and that's enforceable. And if they don't pay it, then anytime after 21 days expires, you can seek enforcement of it through garnishment, through having the bailiff to go and collect that kind of thing.
Okay. Okay. Thank you, Your Honor.
All right, thank you, ma'am. Good day.
Okay. Good day. Bye-bye.
I still don't see where that lady came back. All right, Mr. Rosen, on the suffix 3381, I don't see Ms. Hall on here anywhere. I know she came down to court. And I'm hesitant to, and she's filed an answer, I'm hesitant to take any action on this, but I know that she's made some effort to be involved and to engage on this.
Well, Judge, if it please, or if you'll just issue a standard scheduling order, I'd ask for 60-day discovery. I'll send her the bank statements, which all went to her address where the notice went out on Bond Street. She can look them over and maybe she can call me and perhaps we can work out a voluntary resolution.
Thank you, Mr. Rosen. That's a good and proper way to for this to go forward. So I'll go ahead and set it for 11/21/22, and I'm going to go ahead and set that up for 9:30, 11/21.
Thank you, Judge. Just to let you know, just by way of amicus, Judge Giles does what I just suggested routinely. So I decided to share that with you.
Yeah, perfect. All right. We'll go ahead and set it up in that way, sir.
All right, thank you, Judge.